Hello there. I think it's good afternoon, good evening, good morning, depending on the time zone you are in. I'm Nalini Mahadevan, principal attorney at MLO Law, and here in Clayton, Missouri, with locations in Atlanta and Chicago. We practice estate planning and immigration. And today I want to give you an update on what's happening when somebody passes away and they have done a trust plan with us. And so the other day, I have to tell you the story. The other day was I got this call from one of our clients. She said that her husband was dying of cancer, and he had been suffering from it for the past couple of years, but the end was kind of unexpected. He was in hospice, and they had done a trust with us and did not know what the next steps were. And of course we've been practicing for about 19 years, so we do get these calls, or calls from time to time. I mean, not only that somebody's having a major illness, but also somebody suddenly had an accident, or somebody just passed away unexpectedly, and adult children are in our office not knowing what to do. So today I would like to really talk to you about what should be done, what you need to do in preparation for this unfortunate event. Generally, it's spouses coming to us for planning for, they have young children or adult children, or whatever stage of life they may be in. They've done a trust with us or multiple trusts, depending on their needs, where they have special needs children, they own guns, or they have pets, and they have other specialty requirements, large retirement plans. So we do the planning for all those kinds of special assets and property. So what do you do when you're faced with an unexpected situation in which your spouse is passing? So the first thing to do, of course, is while you've come to us, pay particular attention to the final day on which you're coming to sign your documents, because a lot of the stuff that you need to do, what your next steps are explained in very great detail in that last meeting when you're signing the documents. So if you are our client, we've already transferred your main residence into your trust, or it will pass into your trust as soon as the title holders pass away. And we have also named guardians for your minor children, named guardians for yourself in case you're incapacitated, and also have given you a very detailed list of what to do with your assets and how to title them to the trust. So titling them to the trust is called funding. So we've given you very detailed instructions. Please look at those instructions. They're included in your trust package, and that should guide you through the next steps. So if just because you've got a trust, it does not mean that your assets are in the trust. You have to take some actions as the owner of the trust, as the owner of the property, in order to transfer them into the trust. That is, in other words, you got to fund your trust. So what kind of properties are all of these? They can be financial, personal property, real estate, and any of those properties that you may be having. So some of these situations we also come across are property that the deceased has had with other members of their family. I mean, there are lots of people who own property with their parents because they were single at one time, or property with the siblings because they want to benefit those siblings and the spouse is ignored. Maybe it's property that is left only in single name. We see this quite often. In fact, our latest case had 7 checking accounts with a large sums of money in them, but they were all single with no beneficiary being named. So again, go back to the list of instructions we have given you and look at the list. So let's go over what happens. Let's look at some of the stuff. Banks, brokerage accounts, investment accounts, 529s, retirement accounts, 401ks, deferred compensation plans, all these can have beneficiaries put on them. All these can have joint, some of the bank accounts and investment accounts can have joint holders on them. The 401k has to be held individually. All retirement plans have to be held individually, and then you can name beneficiaries on all of them. So first step is make sure you have beneficiaries named on them. If your beneficiaries are under the age of 18, name your spouse as a first beneficiary and the trust as the secondary beneficiary. The reason we say that is that it's important for the spouse to obtain the assets up front. They, in most cases, especially because of retirement, there's just a rollover into their, it's a tax-free event. But if it goes into a trust and then it's rolled out, there may be a taxable event. It depends on what your tax situation is. Secondly, personal property, cars, go to the title, to go to the DMV, especially things like cars and RVs, trailers, mobile homes, all those are, in most cases, are titled through the DMV. So go to the DMV, the moment you have your trust, go to the DMV, title all those assets to the trust. That's a very simple process. Finally, real estate. You may have come to us with our main residence and we've helped you transfer the main residence. But if you have acquired vacation property, timeshares, all those need to be transferred as well. So don't forget, just because you have a trust is not the end of the journey. Then the journey has just begun, and congratulations on starting to plan. Next step is transfer your assets into your trust. Name beneficiaries. Name your spouse as a second owner if possible. If you have more questions, call us. Our phone is 314-932-7111. If you have more questions about the plan you've planned with us, email us, call us. We are very happy to talk to you. Take care, and we will see you in our next video. Follow us both on Facebook and LinkedIn, and visit our website, mlolaw.us.